The Supreme Court just dropped a bombshell, a 6-3 decision that is doing more than tweaking gun laws. It's detonating the entire legal landscape and rewriting the rules for firearm owners forever. If you own a gun, carry for protection, or just believe the Second Amendment isn't a bargaining chip, you need to pay attention. Because this ruling doesn't just matter, it changes everything. For years, governments have stacked permit systems, background checks, and training mandates into a fortress of red tape, demanding you prove why you deserve the right to defend yourself. But now, that fortress is crumbling. The court didn't just tweak the edges. They tore down entire pillars. This isn't a minor update or a tweak to bureaucratic process. It's a full-scale reset. And if you miss the 10 critical rules emerging from this ruling, you're at risk of being caught on the wrong side of the law without even realizing it. You're about to get a breakdown of exactly what's changed, from how permits are handed out, to background checks, to where you can legally carry, and even what kind of guns are truly protected. This matters not just for gun owners, but for anyone who cares about constitutional rights and government overreach. And make no mistake, if you don't understand these changes, you could be making decisions based on old rules that no longer apply. So stick with me, hit subscribe, because every one of these 10 new rules is critical. Ignorance here isn't bliss, it's dangerous. And while I'm not your lawyer, I promise to walk you through what this means in real, practical terms, so you can stay protected, informed, and free. Number 10 begins with the ruling that set everything in motion. The Supreme Court's 6-3 decision didn't just challenge a law, it challenged an entire philosophy. For decades, certain states built their gun policies around one idea: make carrying a firearm so complicated, expensive, and burdensome that most people simply give up. But the court rejected that model wholesale and reaffirmed that the Second Amendment doesn't hinge on permission slips, subjective judgment, or political climate. With a single ruling, the justices made it clear that access to lawful self-defense isn't a favor the government grants. It's a right the government must respect. That message sent immediate shockwaves through both federal and state courts, triggering a review of dozens of policies that relied on giving authorities broad discretion to delay or deny permits. And that's just the beginning of what this ruling set off. Number 9 focuses on the collapse of the prove your need first system. States that operated under these may issue frameworks are now being forced into compliance whether they like it or not. The idea that you must justify to the government why you want to protect yourself no longer stands under constitutional scrutiny. States like California, Maryland, New Jersey, and Hawaii, long known for restrictive issuance processes, suddenly found themselves on the defensive. Legal challenges poured in, and judges wasted little time pointing back to the new 6-3 ruling as the controlling standard. What's left is a landscape in which objective criteria, not subjective judgment, control the process. Meet the requirements, get the permit. Simple. And for millions of people living in states where approval once depended on unpredictable bureaucrats, this shift is historic. Number 8 exposes one of the government's quietest and most effective tools for slowing down gun ownership: time. Anti-gun states learned long ago that if they couldn't outright deny your application, they could simply delay it indefinitely. Month after month, background checks pending review, permits stuck in processing, offices claiming backlogs that conveniently lasted years. But under the court's new guidance, unreasonable delays can no longer be brushed aside. Judges are treating slow-walking applications as what they truly are: violations of rights. Several lawsuits have already forced local agencies to adopt strict timelines or face court-ordered compliance. In some cases, states are being sued simply for ignoring their own deadlines. The message is clear: when the right is constitutional, you don't get to freeze it in administrative limbo. Governments now must act efficiently, transparently, and on time, or be dragged into court. Number 7 targets one of the most controversial issues since the ruling: mandatory training requirements. While training itself is a good thing, states began weaponizing it with increasingly unrealistic demands. 8-hour classes became 12. 12 hours became 16. Some places required live fire qualifications that only a handful of ranges offered. Others stacked fees on top of fees until the total price of training hit hundreds of dollars. The court's new historical test is ripping these tactics apart. If burdensome training wasn't a requirement in the founding era, modern states have no business using it to make rights inaccessible. Several states now face direct lawsuits challenging excessive training hours and costs, and early opinions are leaning towards striking them down. Courts are recognizing a pattern. The more time, money, and hassle required, the fewer people can exercise the right. And the judiciary is no longer tolerating that strategy. Expect training-based restrictions to be one of the most heavily litigated areas moving forward. Number 6 lands squarely on background checks, not eliminating them, but forcing them to be fair, functional, and fast. The federal NI cut system was always meant to be efficient, but some states layered additional reviews, extended waiting periods, and redundant checks on top. California, for instance, imposed a blanket 10-day waiting period, even for buyers who cleared background checks instantly. Washington's recent permit-to-purchase process introduced long wait times for even basic firearms. But the court's ruling shifts the burden onto the government to justify every delay. If a buyer is legal, law-abiding, and not prohibited, the state can't create slow-motion denial systems through administrative clutter. Several judges have already questioned whether multi-day or multi-week waiting periods have any historical analog. When no such tradition exists, and it doesn't, these delays are constitutionally vulnerable. Expect lawsuits, appeals, and heavy scrutiny on every policy that drags out the purchase process without cause. Quick pause right here. If you're still with us and you appreciate staying ahead of these changes, make sure to like the video and subscribe. It helps us reach more Americans who deserve to know the truth about their rights. All right, let's jump back in. Number 5 takes aim at broad bans on common firearms, right? Particularly semi-automatic rifles and standard capacity magazines. The court reaffirmed something gun owners have argued for years. A firearm widely owned by law-abiding citizens for lawful purposes is protected. That means AR-15-style rifles and magazines holding more than 10 rounds can't be dismissed as unusual or dangerous when millions of Americans use them for home defense, sport, and everyday carry. Judges in California, Illinois, and other restrictive states have already used the court's new decision as a basis to strike down or enjoin their bans. And while some rulings are still on appeal, the trajectory is unmistakable. Bans on common firearms are losing their legal foundation. The divide between what anti-gun lawmakers want and what the Constitution allows is growing wider by the day. Number 4 looks at a loophole states leaned on to undermine the ruling, declaring nearly every public space a sensitive place. Instead of denying permits outright, some states tried designating subways, parks, restaurants, sidewalks, parking lots, buses, and even private businesses as gun-free zones. New York led this push with its Concealed Carry Improvement Act, effectively turning most of the state into a patchwork of off-limit zones. But courts immediately called foul. Sensitive places must be historically grounded and genuinely tied to safety and security, not expanded to inconvenience carriers or nullify the right entirely. Judges have started rolling back these overreaching designations, ruling that governments cannot declare entire cities sensitive by default. Expect more failures of this strategy, as nearly every state that attempted it now faces active injunctions and constitutional challenges. Number 3 shifts the spotlight to the federal versus state clash. Certain states have not taken the court's ruling quietly. Instead, they scramble to produce workaround legislation that essentially reintroduce the same restrictions using different wording. But federal courts have struck back aggressively, reminding state lawmakers that the Constitution is not optional. When a federal ruling clarifies the meaning of the Second Amendment, states do not get to reinterpret it to suit their policy preferences. Cases in New York, California, and New Jersey prove this point with courts blocking large portions of newly minted restrictions. Federal judges are making it clear the Supreme Court's ruling is the controlling standard, and attempts to sidestep it will be shut down. The power struggle continues, but the Constitution is winning. Number 2 digs into the heart of the ruling, the historical tradition test, often called the Bruin test. This is now the single most influential tool in every gun rights lawsuit nationwide. The court's decision kills the old two-step framework, which allowed states to justify restrictions using modern crime statistics or public safety arguments. Those days are over. Now, if a gun regulation didn't exist, or have a close analog. In the founding era, it's presumptively unconstitutional. This standard has already toppled license schemes, carry restrictions, age-based bans, and equipment rules. Judges aren't balancing interests anymore. They're looking for historical evidence. And when states can't find that evidence, which is often, their laws fall apart. This test is reshaping the entire legal battlefield, giving gun owners a consistent, powerful shield against overreach. Finally, number 1 addresses the future. And the truth is that we're only in the early stages of this transformation. This ruling cracked open the door, and now lawsuits are pouring through it. Challenges to assault weapon bans, magazine limits, training mandates, ammunition restrictions, carry zones, and even federal regulations on pistol braces and frames are advancing rapidly. Several cases involving people under restraining orders or young adults seeking carry rights are already on the Supreme Court's radar. Constitutional carry is spreading, state resistance is weakening, and gun rights attorneys are more active than ever. But none of this means the fight is over. If anything, it's entering its next phase. Anti-gun lawmakers are experimenting with new strategies, and each one must be challenged and defeated in court. Rights stay strong only when citizens stay informed, engaged, and ready to stand up for them.